presentation. And we're just going to go ahead and begin. So first off, I'd like to just inform you all that the information I'm about to give you tonight is current, and it's correct as of tonight, of March 20 of 2024. But if you're watching this on recording, if you took notes and are, conferring with those notes at a future date, just know that the law does change. So although that it's accurate as of today, it's not necessarily going to be true and correct a year from now, years from now, etc. So it's always a good idea to talk with an attorney whenever you have any sort of legal issues, because attorneys are going to keep up on the laws and changes to those laws. So who is the Legal Aid Society of San Bernardino? We're a nonprofit 501c3, and we offer completely free services. And these services are offered to seniors as well as low-income families. And we assist not only San Bernardino County, our namesake, but also the entirety of Riverside County as well. We handle a number of issues, so although I'm talking about housing laws tonight, if you have other issues of law that you need help with, feel free to give us a call. We help in a wide arrangement of different types of law, family law, to name one, guardianship, conservatorship, and even if we don't practice the type of law that you need help with, we can help get you a referral to somewhere that does practice that type of law. With that said, let's kick off tonight's presentation. So I've chose first several topics that I see come up every single day on our housing hotline. These are burning issues that tenants frequently have and frequently want answers to in regards to their questions. So the first topic that I see constantly is landlord harassment. What do you do when you're the tenant and you have a landlord that's just causing you problems and harassing you and being awful to you? Well, first and foremost, if the landlord is causing some type of breach of the peace, the first thing you should do is call the police. So if the landlord is in the process of changing your locks, if the landlord is threatening you with violence, if the landlord's actively coming at you with violence, if the landlord's removing your personal possessions from the property, if the landlord's turning off your utilities, a pretty good idea is going to be to call the police, because any one of those acts that I described are likely a crime, and the police can likely get involved and perhaps put a stop to it immediately before you're harmed or injured, and that can often be the best practice. Now, if there is some type of threat of injury, threat of harm, or any actual injury that does occur, keep in mind that not only can you call the police, but you can also attempt to get a civil harassment restraining order against your landlord. Yes, you can in fact get restraining orders against landlords who are causing you injury, posing a substantial threat of injury to you, or causing you a substantial and severe nuisance and annoyance. If there's any type of shut off of utilities, like I was saying, make sure you're calling the police and documenting this behavior as well, as this type of behavior, turning off your utilities, locking you out, throwing out your belongings, not only is that a potential crime, but that also creates liability for your landlord, such that you can sue them. You can take them to small claims or civil court and sue them for any actual damage that they caused you. And in addition to that, $100 a day for each and every day that you're the victim of this type of behavior. And that can be found in Civil Code 789.3. I would like to end this topic by pointing out if all the landlord is doing is being unpleasant, maybe they're just not fun to be around. Maybe they're calling you mean names. They're not talking to you politely. Unfortunately, none of these things are actionable. You're not going to be able to get a restraining order for that. You're not going to be able to call the police for that. In the United States, we enjoy freedom of speech, and that does include annoyance speech sometimes. And if you're encountering that, what I'd like to remind you is, while you don't have a legal option, you do have a real world option. And the real world option is you don't have to have any sort of conversation with your landlord ever. Your only obligations as a tenant are to pay your rent, maintain the home in a reasonable manner, and comply with the lease. So unless your lease indicates that you have to have some type of conversation with your landlord, you don't. So if you don't like what they say to you, if you don't like them, just turn the other cheek, walk away, ignore them. Understand that you have no duty to sit there and listen to them tell you mean or awful or ornery things. Next, we often see landlords who understandably they own the home, so they believe that they're entitled to do whatever they want with the home. But California law constrains the landlord, especially when they rent that property to someone else. When a landlord rents you the property, you are essentially paying to enjoy the use of that property. So the landlord no longer gets to enjoy the use of that property because you're paying to use it. So a lot of times a landlord still believes they have the full and complete right to enter the property at their leisure whenever they want for any reason. That is incorrect. California law tells us that a landlord can enter the home, and this law is found under Civil Code 1954. But to do so, they generally need to provide you written notice 24 hours in advance. And the written notice has to indicate for what reason, and it has to be an acceptable or allowable reason under the law. Such reasons are in cases of emergency, to make repairs, to exhibit the home to potential purchasers. So if they're selling the home, they do have a right to show off that home, but they would need to give you 24 hours written notice first. If there's any court orders for the landlord to enter, or of course, if you consent to them entering, they can enter. Habitability is a really fancy sounding word, but it stands for a very simple concept. In California, under California law, tenants who rent from landlords are entitled to a home fit for human life, free from major defects. The home should largely be free of infestations, have working plumbing, have working electricity, have a working heater, be weatherproofed, such that the home can withstand the elements, both cold and heat. And if you're not receiving these types of things with the housing that you are paying for, you can then notify the landlord. It's better to do this in writing, because if you do it orally with spoken words, it's my experience that many landlords will lie and say you never told them about these problems. So doing so in writing, while it is not required, is usually intelligent because it leaves a paper trail. And you can then keep written proof that you notified them. So that is going to be my recommendation, is if you're encountering these situations, that you notify the landlord of these situations in writing, and that you demand repair of the property. Now, California law does allow the landlord time to make repairs. They don't have to snap right to it and fix it right then and there 30 minutes after you tell them, but they do have to fix it within a reasonable time. California law tells us that a reasonable time is usually 30 days. So the landlord generally gets 30 days to repair these problems that you report to them. Now, if the landlord does not make those repairs within 30 days, now they're in violation of the implied warranty of habitability. So that's where that word comes from. And when this happens, the tenant can consider certain remedies. Now, a lot of these remedies are risky. Understand that. And you should strongly consider talking to an attorney before utilizing any of these remedies due to their risk. But perhaps one of the least risky things you can do is notify code enforcement. If you've reported these problems to your landlord and they have not fixed them for 30 or more days, consider calling your local city, county code enforcement, who has the power to come into the property, inspect it, and if it does not conform with California law, can then begin fining the landlord, which generally, in my experience, tends to result in repairs actually being made. So this can be a very powerful remedy. So something to certainly consider. Your other remedies under the law do include withholding 1 month's rent and making repairs with that amount of money, or withholding rent entirely. Now, again, I do not personally recommend either one of those approaches, especially if you have not already talked with an attorney and been advised on doing so, because typically what happens when you do that is you immediately get a 3-day notice to pay rent or quit, and the eviction process begins. We'll discuss that more.
Carl, I'm sorry to interrupt you.
Yes.
I am not seeing, when I see the presentation, it's stuck on slide 17. I don't know if
17.
others
Interesting.
are having that same problem.
Let's see. Perhaps. Okay. let me try something else. Give me just a moment.
Sure.
I'm gonna stop this. I think I know what is happening, and hopefully it lets me fix it. This might work. And thank you for telling me about that.
Of course.
All right, here we are. So now I should say what to do if you've received a notice. Is it on the correct
Yes,
slide?
now I can see it. Perfect. Thank
Splendid,
you.
wonderful. Thank you. So the next most common issue we see at legal aid is tenants receiving some form of written notice from their landlord indicating to them that they're going to terminate their lease and start the eviction process. If you are a tenant and you receive a notice like this, what should you do? Well, first and foremost, get advice from an experienced and competent attorney. You can consider calling the Legal Aid Society of San Bernardino if you receive some such notice. Other than that, if it's a type of notice to pay rent or quit, meaning you're behind in some type of payment, perhaps late fees, perhaps rent, etc. If you fall behind in these payments and you have the financial ability to pay, that's probably going to be the most advisable situation, because that's going to hopefully avoid the eviction process altogether. If you pay during the 3-day notice period, satisfy the notice, then they won't have a basis to evict you under that notice. So that is the main thing to do if you have the financial ability to do so. Now, if you receive a different type of notice, such as a notice to perform covenants or quit, this type of notice is telling you that you're in violation of some term of your lease. Common violations of lease terms that we see are pet or guest provisions of a lease. It's very common for the language of your lease to tell you whether or not you can have pets, what type of pets you can have, and how many. It's also common for your lease to tell you what guests you can have and for how long and who can live on the property. So for instance, if you had your aunt Tia come over to the home and she's been there for 2 months, and the language of your lease says that you cannot have guests in the home for longer than 7 days, you would then be in violation of that lease provision, and you could potentially get a 3-day notice to perform covenants or quit for violating that lease. And it will tell you that you will have to remove Aunt Tia in order to comply with the lease within the next 3 days. And if you fail to do that, you can expect the eviction process to start. So what we recommend is if you're capable of doing so, you comply during the notice period. You get Aunt Tia to move from the home within the next 3 days. That way you can be in compliance, and then you should document that compliance and keep proof that you've complied in case the landlord later tries to claim that you didn't. Now, if for whatever reason you cannot cure the notice that you've received, you should expect an eviction to be promptly filed after that notice expires. So if you receive some type of 3-day notice to pay rent or quit, well, court day 4 or beyond after you receive that notice, the eviction could be filed against you as soon as that day. If you discover that there's been an eviction filed against you, you should immediately prepare and file a response to that eviction at the court that it was filed against you at, okay? In order to find out if an eviction has been filed against you, if you reasonably believe that an eviction is likely to be filed against you, it's a pretty good idea to start calling the local courthouse and asking, has there been any eviction filed against me? We do not at Legal Aid recommend that you wait to be served with an eviction because in our experience, some landlords have no intention of ever serving you and might intend on just lying about serving you and trying to default you and win automatically against you behind your back. So in order to avoid this, the best way to combat this is to call the court once a week, every week, if you reasonably believe there's an eviction going to be filed, and figure it out yourself directly from the court. Okay, so during the COVID-19 period, it's a very small period in time that is now gone. During that time, if you suffered a financial hardship due to COVID-19, you could have submitted to your landlord a written notice telling them that you had a financial hardship and you couldn't pay your rent. And as long as you paid 25% or more of the rent during that time, the landlord could not evict you. And in fact, they still can't evict you for that lack of payment. But you should know that they can still sue you in small claims court. And they still have the right to do that all the way through October 1st of 2025. So we're not there yet. We've got a bit over a year that the landlord can still sue you for that back rent in civil court or small claims. And now on to the main reason for this presentation. In around 2019, there was a significant suite of laws that were passed in California. These laws are known as AB 1482 or Assembly Bill 1482. They cover Civil Codes 1946.2 and Civil Codes 1947.12. This was a very significant change in the law because prior to 2019, landlords could evict you under a 30 or 60-day notice for no reason at all. Maybe you had an earring in this ear and the landlord hated it. Well, they could have evicted you for that back then, pre-2019. But now the laws have changed. So let's talk about the ways in which the laws have changed since this time, thanks to Assembly Bill 1482. One of the first things that AB 1482 does for people that live in an apartment complex or other protected properties, these persons now enjoy a rental cap. The landlord can no longer raise the rent for persons living in an apartment more than 10% in a single year. In addition to this, there is also cause requirements created under Assembly Bill 1482, such that a landlord requires cause to evict you if you live in certain property types, such as apartments, and you've lived there for longer than 12 months. Oh, give me just a moment. So the first part of AB 1482 that protects you from increased rents, again, this applies only to certain categories of units. So this isn't going to be across the board. This isn't every single rental property in California. No. Only certain types of property enjoy this protection. But as long as you're that type of property, you do enjoy not having your rent raised more than 10% in a single year or 5% plus the cost of living, whichever is less. Though right now inflation is rather high, so it's still that 10% figure. Now, in order to determine if you're covered and you enjoy these protections, you have to live in an apartment complex, a single family home owned or controlled by a corporation, a mobile home, if owned by the mobile home park, or a duplex in which the owner is not living in one of the units. These units are covered and enjoy these protections. What properties do not enjoy these protections? The main type of property that does not enjoy these protections, that does not have any association with this law, is a single family home owned by a private individual. So if it's a mom and pop owner, it's a non-corporation, it's just, Rob up the street, he has an extra spare rental and he rents it. He's not going to be beholden to these laws that I'm telling you about now. Now, also a duplex where the owner lives there, also not beholden to these laws. Various other types of special properties, such as nonprofit housing, tourist, hotel occupancies, etc., are also exempt. Cause. We had indicated that before 2019, landlords did not need any cause to evict you under a 30 or 60-day notice. That has changed since the passing of this bill. Let's do a deeper dive into that and understand more about what cause is and what a landlord has to do to evict you now since the passage of this law. First, it's important to know that you are not entitled to just cause if you have lived in the property for less than 12 months. So if you've been in there for 1 month or 11 months or anywhere in between, you do not enjoy the benefit of being entitled to cause to be evicted, meaning the landlord can still evict you if they don't like your earring. But as soon as you've been over that magical 12-month mark, assuming you live in the property by yourself and you don't have any new adults come in, boom, you automatically get those protections and just cause entitlements before the landlord can serve you such notices. Now, it's important to know that if you allow a new adult roommate to move into the property during these 12 months, Instead of it being a 12-month timer for these protections to go into place, now it becomes a 24-month timer. So make sure that you understand that before you allow another adult roommate to enter the home. Now, we keep saying cause. Landlord needs cause to evict you, but we haven't yet explained what types of cause are there. So there's two main types. There's at-fault cause and there's no-fault cause. At-fault cause are usually the types of causes that you think about for reasons for why a landlord would evict a tenant. These are things that the tenant usually did or failed to do, such as failed to pay their rent. They breached a term of the lease. Remember, I told you earlier, if you allowed your aunt to stay there for longer than the lease allows, you're in violation of the lease. This is a causal reason to evict. Or if you're using the property in a manner that it's not fit for, if you're running a barber shop out of your apartment building, that's likely not using the property in a way that it's zoned for or allowed to be used for under the lease. And that would be for an unlawful purpose, and you might be able to get evicted for that. Criminal activity on the property. Refusal to allow your landlord to enter. Remember, we talked earlier about the landlord's ability to give you a 24-hour written notice, and then they have the authority to enter the home. If you don't allow that, you could potentially be evicted for it under this type of cause. Now, the other type of cause, no fault just cause, is completely different. You could be the perfect tenant, the perfect human being, and still get evicted under certain types of no fault just cause. These types of reasons tend to involve the owner's desire to move into the property and live there himself, or move one of his family members into the property, the owner's desire to stop renting, to remove the property from the rental market, the owner's desire to perform a substantial rehabilitation of the property, something that might involve government permits to do, like maybe ripping out all the plumbing and reinstalling new plumbing or something like that. Intents to demolish the property, so if they're going to bulldoze it, or if there's some type of government or order necessitating you to leave. These are all recognized no fault just cause reasons that you can be evicted for. Now, whenever you are being evicted for no fault just cause, when you receive the requisite notice, likely a 60-day notice for no fault just cause, that notice has to tell you that you're entitled to 1 month's relocation. Whenever you're getting evicted for no fault just cause, and you've lived in the property for over a year, you're not only entitled to the no fault cause reason, you're also entitled to relocation payment of 1 month's rent. And this is regardless of your income level. You could be a millionaire and you're still entitled to that 1 month's relocation payment in the event that you're being evicted for no fault just cause. The rent cap. As we were discussing earlier, generally, as long as you live in something like an apartment or one of the covered properties that we referred to earlier, you enjoy the fact that your rent cannot legally be raised more than 10% in a single year, or 5% plus the cost of living, whichever is lower. Now, as inflation goes down, it might actually be even less than 10% that the landlord's legally allowed to raise your rent. Though generally, around this time period and leading up to this time period, inflation has been rather high, so it's been 10% has been the threshold cap. There's a little bit more to this. This law also limits the number of times the landlord can increase your rent in a single year. The landlord can only increase your rent twice in a single year, and together, those increases cannot be more than the cap. So 2 rent increases, one for 4% and another for 4%, is likely to be legal under this structure. But if there's a third increase in a year, that would not be legal. Or if the increase, the second increase, or the third increase made it more than 10% increase in a single year, those increases would also be illegal. Now, we just got done talking about changes to the law back in 2019, but what about changes to the law for 2024? There's some brand new changes to the law that have hit this year and are going to take effect very soon. One that takes effect beginning April 1st, and another that takes effect beginning July 1st. The first that takes effect on April 1st is updates to the law that we've been talking about this entire time, AB 1482. As we've mentioned, this law is about 5 years old. It came out in 2019. Well, since that time, we've learned that there were several loopholes in this law that many landlords were abusing. The changes to the law beginning April 1st seek to close a lot of these loopholes. And just from experience, I'll indicate what some of these loopholes were and how this change to the law might help. So we had indicated that one recognized no fault just cause reason to evict a tenant would be the owner's desire to move in or have one of their relatives move in. This has been the case since 2019. But these new changes to the law beginning April 1st are going to require significant amounts of documentation to be provided to the tenant, such as who is it that's going to be moving in? What relation are they to the landlord? When will they be moving in? Are they moving in within 90 days or are they not? Or are they going to be there for at least a year or are they not? So in addition to requiring these documented changes, in addition to that, the law now is very clear. If that person does not move in within 90 days, the landlord must offer you, the tenant that got removed, the opportunity to re-rent the property at the exact same terms that you previously enjoyed. It also very clearly states that this person needs to move in within 90 days and they have to live there for at least a year. Whoever the relative of the owner is. The law was unclear on this before, so now it has been made very clear what these requirements are. So in the event that your landlord strays from this, you might have the ability to sue them for their non-compliance, which is something that you did not really enjoy previous to April 1st of this year. There's also been some changes to the documentation requirements for an eviction based on a substantial renovation. What we were seeing was a lot of notices that used the phrase substantial renovation, but said nothing else. It didn't say what work was being performed and was unclear if in fact any work was being performed. Now, if you're being evicted for this reason, the landlord must provide you clear documentation that says exactly what work is to be done, how long that work is going to take. It must include the necessary government permits that are required to perform this work, or it must include a copy of the contract that the contractor has made detailing what work is going to be done. These changes are likely to close these loopholes or substantially limit them and result in fewer evictions that were essentially bogus, that had no real basis, where the landlord was just saying these things on paper but had no actual intention of doing them. So that's what we anticipate we'll see with these changes on April 1st to those laws. Now let's talk about the changes to the laws that go into effect on July 1st of this year. These changes are regarding security deposits and various security deposit laws. So effective July 1st of 2024, landlords can only charge a security deposit equal to the value of 1 month's rents, whether the unit is furnished or not. So regardless of whether or not the unit has furniture or not, the landlord is now only going to be limited to charging you up to 1 month's rent for the security deposit. Current laws in effect before July 1st allow for much higher security deposits amounts, 2 times the normal rent, or even 3 if it's furnished. So this is going to be a significant change to the law beginning July 1st that's going to make it to where landlords cannot demand massive security deposit amounts, or perhaps even better, they won't be able to change the terms of your lease to demand this. Because what we were seeing was, in order to perhaps subvert or navigate around these protections that I've been telling you about, landlords were serving 30-day written notices indicating that they were raising the security deposit amount to the maximum amount allowed under the law, which oftentimes, in addition to your payment of rent, could have been thousands of extra dollars. And if you didn't pay that, you could have been evicted. So this is likely to stop a lot of that because they're only going to be able to limit the security deposit to 1 month's rent. So you likely aren't going to get that surprise notice of increase in the future. Or if you do, it's not likely to be some gargantuan amount that you cannot afford. That concludes this presentation of the California laws, California tenants' rights, feel free to give the Legal Aid Society of San Bernardino a call if you're encountering any of issues related to this or just any legal issue in general that you need assistance with. We handle a wide assortment of topics, not just housing law, and in the event that we can assist you, we'll refer you to someone who can. Thank you.